Well, Alan, I am really happy that you're here with me today. This is kind of weird to be on a podcast. It's probably, maybe, hopefully your first time being on one like this, but...
well, appreciate you having me.
Yeah.
Good to be here.
I'm really hoping that this, the Retirement Experience podcast really helps people in our area who are in that retirement age, whether they're 50 or 60 or 70, have some resources that are local that they can go to and say, oh, that's similar to what I'm going through, or that provides me some help. And then there's local people that they can reach out to have questions answered. And so I appreciate you coming on. So it's a conversation between two professionals, a financial planner who helps with retirement planning and an estate planning attorney. So this is really fun. Your experience with complex trusts and estate planning. And as I look around at, the half a dozen or so estate planning attorneys that I've worked with in the past, I don't know if I've ever seen anybody who has focused their business so perfectly aligned with everything that you're doing is estate planning. I mean, when I met you at the Ammon Days and these flyers about estate planning and probate and the guardianship and conservator tours and your website, just everything that you've done has just aligned and super focused yourself into estate planning and becoming, I think 2024, you won the best law firm in Idaho, or East Idaho. I don't know which one it was, but that was a pretty big award for you. So I guess first, how did you get to a point of really focusing so intently and aligning your entire practice towards that?
Yeah, no, thanks for asking the question.
Yeah.
And just you have different kinds of attorneys in the world. There are planning attorneys that like to think, okay, what's coming up? And what's the reality of the situation? And then they make a plan for how to deal with that based upon the reality. And then you've got more of the reactionary attorneys where you're dealing with like a divorce or custody type of a situation where two people aren't getting along and they're not able to navigate it together, and so they need to be divorced for their own benefit. And then we have the criminal attorneys where we've got, a crime's been committed or alleged to be committed, and so you're representing them then. Or there's litigation where people are in a dispute and they just can't solve it, and so then they got to go litigate. And I've been a prosecutor. I came to Idaho Falls actually as a prosecutor back in 2003 is when I came, and prosecuted for 3.5 years. And I'm not a career prosecutor. I'm grateful for the experience, and it was great, but I just felt like people need to plan more. And I opened up my own practice in 2007. And when I opened up my own practice, I only wanted to do estate planning and business law, and I didn't go in with anybody, just went out on my own. And after a while, I realized I needed to just do whatever came in the door at that point in my career.
Yeah.
And so ended up doing a lot of divorce and custody for about 8 or 9 years, and just got to a point where I didn't feel like I was really making a difference, really helping people get a hold of what their issues were and helping them move forward. And so the last, 10 years or so, I've just really continued to refine and refine and refine it. And it's been a journey to get there, to just really focusing solely a practice that is planning for the future, identifying what the reality is right now, and then making a plan, whatever that is. And that's the nice thing I like about estate planning is it's not just a cookie cutter, one size fit all. It's more of listening to the individual, understanding what their vision, what their goals are for themselves, their family, and their assets, and then putting together a plan that best suits them.
Yeah. There's so much overlap between financial planning, retirement planning, and estate planning with just what you said. I mean, and the same joy, I guess, in the work that you do is,
it's a lot less stressful, way less stressful than litigation.
It's so nice to the families that you get to interact with, and then at the end of the day, I mean, you're taking someone who's potentially doesn't have a whole lot of visibility of what that next step looks like or what their future looks like, and the anxiety that comes from not having things organized, and being able to just illuminate all of the dark corners and push all that anxiety out and have a plan that helps them move forward with confidence. Like everything is in place. Like on an estate plan level, everything is documented the way it needs to be, the wills or trusts or all those things. We know exactly how to move our life forward. And on the financial side of making sure that their funding is happening, and that they don't have to worry where that next paycheck is, and that all of those pieces are really intertwined. And
it's a much better feeling. We did an estate plan for someone the other day that made some difficult decisions based upon the reality of some addictions that their children had, and they'd made one decision, we had done it, and they called us about a month or two later and said, no, we need to change this. And after I had signed the document, I was leaving the room, and as I was leaving the room, she just turned to her husband and she said, this is right. This is good. And it was just this feeling of like relief, just this, it was a palpable feeling of relief that they had done what was best for them in their situation. And you just don't get that in other areas of law.
When you're litigating.
Yeah.
When there's a divorce happening and two angry sides.
Yeah. So it's just, I like bringing relief and relieving that burden, like you said, that when they have their estate plan in place, they know where their money's at, they know what assets they do or don't have, then it's so much nicer for them, and most importantly also for the surviving spouse and whoever is going to be taking over after both of them are gone. It's just provides a lot of relief to them.
Yeah. So my experience on the financial planning side, I would say a very small minority of amount of people have done their estate planning before I talk to them. Some have it, but I mean, they're a minority. And so I, sending 15 to 20 referrals out to, get estate planning done is a common thing for us. So one of my questions is, like, that's me looking out through my lens. Like, when you see people coming into you, are they typically visiting with a financial planner first? I mean, is that a large part of it, where people are coming from a financial planner where they say, you need to get your estate done? Or is it people who are just organically coming to your office without any help other than they know they need some help done? Like, what, does that make sense?
Yeah. So we have a lot of clients that do come from estate plan or from financial planners or from others. A lot of them, and I don't have exact percentages, but a lot of them just come organically also, either from former clients, or I've kind of started keeping track a little bit more and have kind of identified 3 big areas where people really usually come in.
Okay.
A lot of times if there's been a health diagnosis or they've had a health scare, then all of a sudden something that they've thought about doing for a long time, they realize, I need to take care of this and I need to do it now.
Yeah.
And so that's often I see that have helped people with cancer. They got diagnosed with cancer and then they decide they need to come in, and some have come. I had one the other day that he passed away. We set up a signing, and within 2 days of them meeting us, and he didn't make it 2 days.
Oh,
and
geez.
So on that we just need to try and help them out. But the other area that we've really seen is when they're having a bad experience. So if they're probating or dealing with a trust from their parents, and family isn't getting along, or friends, or just however it goes, when the family's not getting along and they're having a horrible experience, then that's kind of usually the second big area when they say, I don't want this to happen to my family. Yeah. So I'm going to plan. And then the third is just that they get to a certain age, usually in their 40s, their 50s, sometimes 60s, and sometimes 70s, where they finally just say, okay, I know I need to do this, and I'm not getting any younger, and I'm just going to do it. Yeah. And so they sit down and we work out a plan for them, and it's always great when they come from a financial planner because they're already thinking about that. And so maybe if I could ask you a question. Yeah. So how do you help people if as those people that don't have an estate plan in place, I guess kind of how do you help prep them to prepare them for when they go see the estate plan?
No, that's perfect. And there's all kinds of different people that you run into, and whether you have a man and a wife that's been married for 40 years that's come in and doing retirement planning where they're the only couple they've ever been married to, and all the kids are under that person, and that's a pretty simple conversation about there's not a lot of really complex needs that are in there, but understanding a lot of times when you have a couple who has it's a mixed family, and you start just having the conversation about what the beneficiaries are to accounts, successor beneficiaries. So, each spouse is that, but, kids from different marriages, how is that going to work when it comes to beneficiaries? And that catches them by surprise sometimes, where they're like, I haven't really thought about outside of me passing it to my spouse. And yeah, that's a little more complicated. So we start having conversations about, the splitting of assets and what does that look like, and kind of try to just see what their goals would be and how, if they're on the same page, and then say, we need to get this documented. We need to get you over to an estate planning attorney. We need to get a will in place or a trust in place or other things, and make sure that those documents are done correctly. And then we have to make sure that that's documented on our side and all of the accounts are aligned with their wishes. And so that's kind of how that kind of starts. I'm seeing a lot of people too that are not, they're a companionship. I don't know the best way to explain that, but they're just not married and they're living together, so they're a companion. And so the conversation there too is like, well, if you pass away and it's separate property, like, do you intend for the primary residence to still be there to support your partner? And so, are you going to look at a living estate or some other type of documentation to allow assets to transfer and then go to your own kids after that? Like, so those are just good conversations and to have starting, I guess, planting a seed, and then just really encouraging them to move forward with an estate planning attorney to get those conversations really buttoned up.
Right. And we just recently had a conversation on that very issue just yesterday, actually. Yeah. Just with two people that were living together, and as to what's going to happen when one of them passes.
Yeah.
And who's going to be able to, is the non-owner of the home going to continue to live in the home? Mm-hmm. And if they're living in the home, who's going to pay the utilities, major, minor repairs, the taxes, the insurance? Is it going to be the person living there, or is it going to be the other individual's trust? And who's going to manage that? Is it going to be that individual, or is it going to be the children of the owner of the home? And just working through those issues. And once again, with estate planning, there's no right or wrong answer. It's what's best for you and your family.
Right.
And that's what I seek to try and understand.
Yeah.
Is what's best for them, and get that documented, like you said, so it's clear.
Yeah.
To everyone. And that issue also, this week I also dealt with a second marriage where a blended family, where the wife had sold her home in Montana and had moved into his home here.
Okay.
And so you have the same issue.
Yep.
As to, if he dies first, can she live in there? And I've had, within the last 2 weeks, I've had some say, well, she can live there 6 months, and then they need to move. And the spouse is wanting to move because this isn't where they're from. They're wanting to leave. I've had others say, no, we're going to let them live there for as long as they want and stay there. And so it's really about what's best for them.
Yeah.
And getting them going. And so.
Yeah, and I've seen a couple horror stories in my days where they just didn't get they either didn't want to cause an argument between spouses. Maybe they weren't quite getting along as much as they were hoping, and so having this conversation of a split blended family and who gets what is something that was so uncomfortable that they just wouldn't do it. Mm-hmm. An extreme example was there was an old friend of mine whose dad had this property up at the lake up in Island Park, and 3 generations they've owned that cabin. Mm-hmm. And the dad wanted to buy the other brothers out, which is a good idea. I mean, don't leave an asset split between different families. It causes all kinds of problems. So he was consolidating ownership, and he got the ownership consolidated to just under him. But then we couldn't get him to finalize the estate planning to where his estate would go to his children, not to her, and if he passed away first, to her and her children. And COVID happened, and he passed away first. All of his accounts, all of his property. There was generations of firearms that Grandpa used and Dad used that I grew up hunting with, and there's this cabin that's been in the family for 3 generations, all gone to this spouse who had been married. I don't remember, it wasn't a few years. This other spouse got all the property, immediately locked everybody out, sold it, and then moved out of the area. And then she died maybe a couple years later, but completely disinherited his children because he wasn't willing to have the uncomfortable conversation that just needed to happen. And the way that really hurt all of his children was unfortunate. And then just this week I had a conversation with a guy who his dad owned some farm ground in the area with his brother, or his dad's brother, and they couldn't agree on how to transfer or share the property or deal with the property before his dad and his uncle passed away. And so they basically created a trust and said, well, the kids can figure it out. Well, now you've got 5 kids on either side of this family that are all fighting over the same property, and it's developable property at this point. And so some of them are like, well, I want the frontage property that has the most value, and you'll get the part in the back that there's no road access. And so there's fighting over like just how to deal with the property. And so, I think one of the things that I encourage people when I'm talking to them is like, please don't leave real estate to your children unless it's a consolidated ownership piece, especially if it's something like a cabin property or big undeveloped property. That I've seen more than not just so many problems with families getting torn apart because of assets that are hard to split. So I don't know if you've had a lot of the same experiences.
Yes, land is very difficult. I always tell clients that if you want to hold land and pass that to multiple owners, that is way more difficult than me taking a $2 million account with 2 kids or 4 kids and giving them $1 million or $500,000 each. It's so much easier. And so if you have land and it's not going to just be sold outright or given to one child, or the one child able to step up and take that as his share, then it just can be very difficult. And you've got to set out very clearly how you want that to be distributed. Another difficult thing that I've seen is with regards to beneficiaries on accounts. And this is where I try and work with the financial planner to make sure this doesn't happen. But I've had a situation where, getting back to that, living with a partner that had an individual that had named his spouse, or not his spouse, his partner as the beneficiary on his retirement accounts. And just before he died, he had received some documents from the retirement account saying you have an account and you don't have a beneficiary on there. And so he named his son as the beneficiary on this account from the retirement. And verbally, he had indicated, I want.
So estate planning wise, it was supposed to go to the spouse, but then he put the beneficiary as his son on the account itself. Yeah.
What ended up happening though is he didn't do an estate plan.
Oh, okay.
He refused to do an estate plan, and verbally had communicated, I want $100,000 to go to my partner, and then some other money to go elsewhere, and then everything else to go to my son. And that had been communicated verbally, but just refused to do an estate plan. Didn't want to face it because he didn't think he was ever going to die. Yeah. Honestly, I talked to the son afterwards, and he just didn't think he was going to die. And when the doctor gave him, and there had been some discussions between the son and the partner and him with regards to how this would go, and literally the day before he died, he had gotten a diagnosis. He got a week to live. Wow. And he told his son, look, I'm going to tell you what I want. And so he told him, this is how I want things to be distributed. And it was all done verbally. And it was kind of understood, at least from my client's perspective. It was all understood what was going to happen. And then he ended up passing away. And as we went to probate the estate, it was unclear who the beneficiaries were on the retirement at that time. And so it came out that when we went to contact them, that there was actually 2 retirement accounts. And he had put his son as the beneficiary of the one that was worth $700. and the one that was worth $700,000 was the one where the partner had been listed.
Oh.
And so in his mind, he was naming his son.
Oh, geez.
But just there was some confusion about how many accounts there were. And
I think people misunderstand that too a lot, where they're like, well, my will says that this is what's going to be split. And they don't realize that the will doesn't matter when it comes to retirement accounts specifically, because whoever the beneficiary is listed on that account, that's where it goes.
Right.
Period.
Yep.
Doesn't matter what your will says. Doesn't matter if it was a trust. Doesn't matter. The beneficiary is where that goes. And so
bank accounts, retirement accounts, stocks, bonds, CDs, anything where you list a beneficiary on them, that's where they go. And I've had that case with this. That was that situation. There was another one where a grandma or a mother had a daughter that had been adopted out very young, and she had named the daughter that she had adopted out as the beneficiary, but her will said everything goes to her grandma, or to her granddaughter. And so the granddaughter probated the will and then went to collect everything, and sure enough, she wasn't to get it. It was to go to this other.
Yeah.
And so it wasn't what our understanding of how things were to be distributed, but you're right, whoever the beneficiaries are. And one issue with that I often run into is on a lot of accounts, some of the accounts will just say, these are my primary beneficiaries. And I don't know, I guess I'd like to get your input on this. On some accounts, I've had experience that they'll be able to designate if the primary beneficiary has been deceased, then it will go to the deceased individual's children, as opposed to just going to the other primary beneficiaries.
Well, it depends on if they've checked the box, if it's per stirps or not. Yeah, how that kind of goes down the path.
And on most accounts, can they make that choice? Because I've had some come back to me and tell me that they can't, and I said, well, because usually in an estate plan, you're wanting that if your children have passed, you're wanting their share to go to their children. And so you just got to be real careful that you work with your financial planner or whoever's dealing with your accounts to make sure if that's what you want and you're not naming your trust as the beneficiary, that you make sure that they check that.
And I think a little bit of that issue is laziness on the part of somebody who's managing an account, to be honest. I think there's some laziness in there because, for example, if I have a husband and a wife, a couple, and they're each other's beneficiaries, and one of them passes away, then you should be making sure that you're updating all of the beneficiaries at that point. You know, not just contingent beneficiaries or how that's going to flow from there, but changing all the primary beneficiaries and going back through all the accounts and updating that so that it doesn't still have a deceased person as a primary, and then they're trying to figure that out. So I think that's really important that, as part of the review process that you have with clients, and as any major life event happens, that those things are done. I also find it interesting too, like occasionally, like it's a little humorous to me. I know it's not on their side humorous, but once or twice a year, I'd have a client that would come into the office and just be like, that's it, they're done. I don't want this kid to be a part of my inheritance anymore. I want him out. I want to change all the beneficiaries. And so, we can make those kind of changes happen, but then just trying to redirect them back to the attorney, and so those documents can be kind of updated and changed. And sometimes we're trying to okay, let's let what's the situation? Can we cool off a little bit and give it a week or two to before we make some of those big changes?
And from your experience, how often are you seeing clients actually name their children as individual beneficiaries on whether it's a retirement or a stock, or just naming the trust? In other words,
it's less common to have the contingent beneficiaries listed as individual children. I'll give you a couple of reasons why. But it's very common if I have a trust to put the trust as the contingent beneficiary after a parent has passed away, because that's easy. One of the things that becomes a problem when you have contingent beneficiaries that are children is if they get remarried, they get divorced and remarried, they move out of the area, their addresses changes. And so all of those changes with the contingent beneficiaries that might happen with children that are in their 30s and 40s or 20s becomes a little bit of a hard thing to continue to manage, especially if there's many of them. Continually trying to keep the contingent beneficiary information current. And where it's a contingent and you've still got the primary beneficiaries of each other, sometimes it's just easier to say, you know what, if something happens, we know what the wishes are, we know what the will says, we have a copy of everything, we know what's going to happen, and we might even have that designed out in the planning software that shows where the contingent beneficiaries are, and we can make sure those updates are done. So again, I think it's laziness on a part of a financial advisor not making those contingents primary at a point of a piece, but less common again for children to be listed as contingent just because of the issues that causes. Very common if you have a trust or something like that. That is easy to it's documented, it's done, it's not moving.
Yeah, and what I tell clients when they do that is that if you have a trust, then you just have to go to one document.
Yeah.
To make changes.
Yeah.
As opposed to having to go to your, retirement, your bank accounts, all that. If you've named all of them as individual beneficiaries, then when you do that, you have to make sure that if you want it to go to their kids, that they mark the per stirpes or by representation on each one of those accounts. And if you ever make changes, then you got to go back to all of them.
Yep.
And so
all those things.
A lot of times, what I advise is like what you said is just make the trust the beneficiary.
Yeah.
And that way, if there are any changes need to be made, you're just going to one place, and it automatically takes care of it without having to go back to all those individual.
Yeah. So let's talk about wills and trusts and beneficiaries for just a second, because we're kind of on this piece. Many say that if you have a lifelong couple that don't have a mixed family, children are all under the same couple, that the state of Idaho actually has a pretty good will, and it's everybody gets everything equally. There's not a lot of turmoil when it comes to just splitting the assets right down the middle and giving to the kids those things equally. And then obviously if you have a split family, wills become, in my mind, like you have to have that completed to solve some problems. But then trusts come in, and for me, it's like I really only have recommendations for trusts if I have a kid with an addiction issue, and so a spendthrift provision of being able to take care of the health, welfare, maintenance, support of that child, but it would be damaging for them. It'd be unhealthy for them to get a large sum of money. Or if there are an estate that's large enough, but the estate, the $15 million now is what the one big beautiful bill kind of made as per person. So $30 million estate are not that common. But spendthrift provisions, where someone wants to control the assets after they pass are important. You might have some split family relationships that need a trust that are important in my mind. But where are you when it comes to, like, you know what, maybe you really don't have to have a whole lot of things done. Maybe just the power of attorneys and the advanced health directive pieces. To you absolutely have to have a will, or you really do need a trust. Where do you start to draw those lines when you talk to people about the documents that they need to draft for their estate plan?
Yeah, so in all of our estate plans, like you mentioned at the end there, that we always include a financial power of attorney and medical power of attorney.
Yep.
To make sure it's clear who's going to help them if they become incapacitated to make their medical and financial decisions. And then from there, whether they want to do a will or a trust, a trust will force you to identify all your assets and force you to identify who all the beneficiaries are. It's been my experience anyways. If you go that route, it just kind of pushes that issue to make sure all those are in order. And I have a lot of clients that in getting those things in order, they want to avoid probate. They don't want to have to go to the court. They don't want the successor or whoever their personal representative is to have to come back to an attorney to file a petition with the court to get appointed personal representative. And that's one common misconception I've found is people think that because they're appointed in a will, that automatically makes them the personal representative and gives them the authority to go into the bank and sell property, and it just doesn't. In a will, you have to go to the court to do it. And so...
And you can decline it.
Correct.
Yeah.
Yeah, you can't force someone to be your personal representative or your trustee. And so if they don't want their personal representative or trustee to have to go to the court, that's when they go ahead and do a trust. The other route that I'm always going towards the trust is if you own property outside of the state of Idaho.
Okay.
So if you own property here and let's say Arizona, for instance, then if you do a will, you're going to have to probate in Idaho to transfer that property, and then you're going to have to do what we call an ancillary probate in Arizona. And so you end up having to probate in both states.
Pay twice.
And the ancillary probate, when you're coming to Idaho, is a pretty simple process. I've had Arizona, it wasn't quite as simple as I recall in what we had to do. But yeah, you're having to engage 2 attorneys in 2 different states to deal with it. And so it's much easier if you have a trust and you just transfer both properties into the trust.
So properties in adjacent states or other states, that's one of your lines.
Definitely.
Yeah.
I'm always encouraging to do a trust when you have property. The other is with special needs kids.
Oh, yes, yeah.
So if you have a special needs child and they're going to inherit over $2,000, then they're going to lose their government benefits. And so we want to make sure that anything that a special needs child would inherit goes into what we call a third-party supplemental needs trust. And this can hold $3,000 or $300,000, and it doesn't disqualify them from the benefits that they would receive. And any money that's not used, you can designate where it goes. And so there's a common misconception I hear a lot also with families with special needs children is that they hear, well, they can't receive any money, so I have to disinherit them. And the first part's true. They can't receive any money or it'll affect their benefits. But the second part is you don't have to disinherit them.
Yeah.
You can create this third-party supplemental needs trust to make sure that their assets are held for their benefit. They can't manage it. Someone else manages it for them.
Yeah.
And so we're always doing a trust to help manage that.
So I've had many clients with special needs children that have needed those trusts, those special needs trusts, and neighbors who've had special needs kids as well. And it's interesting, like, you know, when that kid turns 18, they become an award of the state, and you have to petition to keep your child basically as in your own care, and you have to get the certified family home and. Go ahead. Correct my word. Well, yeah.
Yeah. So when they turn 18, they're still your child.
Yeah.
And they don't become a ward of the state at all. It's just that they're 18, and so they legally have the ability to make their own decisions. And so if someone else is going to make their decisions for them because they can't make them, then that's when either the individual needs to sign a power of attorney authorizing someone else to make those decisions. But if they don't have that capacity to do it, to authorize someone else to do it, then that's when the parents would file for the guardian and conservatorship.
Yeah, I guess that's what I meant is like, but they turned 18 and these kids were uncommunicative. They don't
Right.
have the ability to do any decisions. They had to petition or go to the state to
Correct.
to continue their guardianship of their kid, which has often caught them by surprise.
That's correct.
So maybe the award of the state was the wrong words to use, but they had to petition to get the guardianship. And then there's different benefits that come out with that. And the whole certified family home piece that became really more important. But it didn't seem like, it seems like sometimes that's kind of the age where the parents start to figure out like, oh, well, we might need to have this special needs trust and start really doing a better job with planning around the financial pieces to make sure this kid's taken care of. That's one of the triggers that I see with people wanting to do a little bit more financial planning with their special needs children is that age change. Is that kind of where you see that trigger as well?
With the state planning?
Yeah.
Yes. Yeah, a lot of times because we do guardianships, and our niche is for families with special needs kids. All of my office manager and my manager that handles my guardianships, and actually the one that helps me with probates, also all of them have special needs kids.
I didn't know that.
And so, so that's our niche, is to help families with special needs kids to plan for the future. And often when they're turning 18 and they need a guardianship, they know they've got to do it, or else if their child's not communicative, that they're not going to be able to have that authority to help them. And so they're willing
they're ready to make some changes
to do it. And every time they come in, I always bring up the estate plan piece just to see if they have it, number one, and some do, but most don't, and just tell them the reality of their child inheriting over $2,000 and getting that third-party supplemental needs trust. And I guess I would just throw out also, I've also dealt with some clients where they had done their estate planning, and if they've gone with a good, reputable firm that understands supplemental needs trusts and that, then there's not an issue. But if they're just going to the general civil attorney, I've had people come in 1 year after they had done their estate plan with another attorney in town that's a good attorney, but it's just not his niche. And either he didn't ask the question, but anyways, they did not have a supplemental needs trust. And so we did their guardianship, and then we had to redo their estate plan to ensure that those assets for that child weren't just, that they were protected for their benefit. So.
What are some of the unique things inside of that third-party supplemental trust piece that's different than a regular trust that's important to get right?
Yeah, so in a third-party supplemental needs trust, you have a trustee that is not it's not your special needs child. So it's a separate person that they're holding the assets for the benefit of the special needs child. Other things is you can't use that money to pay for things that the government's already paying for. It's supplemental. So you're supposed to pay for things above and beyond what the state pays for, which is a lot. There's still a lot of things that you can pay for that. And so you just want to make sure that it's clear of what they can pay for so that they don't start paying for things the government's paying for and then they lose all their benefits anyways. And so whoever becomes that trustee really needs to, and we provide a letter to that trustee, and we're available to answer any questions that they may have. We've got someone at our office, Tim, who used to work at a bank and is a trust officer.
Yeah, I know Tim.
And has dealt with these type of issues as a trust, administering these trusts. And so he's a great resource.
I find it interesting that when he left the bank, because one of the things that I've run into, especially with trusts and trustees, is if I don't have a family member that can be a trustee, like that happens a lot. Like I have an only child, or there's nobody else. No, I can't trust the rest of my family to give control of the trust and all of its assets. So, the bank that he was at was kind of one of the only solutions in town that could have an institutional trustee manage the trust for some people. But what other solutions have you run into or found when it comes to the lack of a good identifiable trustee to help manage the trust going forward?
Yeah, usually, like you said, often it's family that is doing that. If they can't find family, then usually it's finding a commercial trustee. And usually that's at banks, having a bank or an institution be the trustee of that. And when I was younger in practice, I thought, family can always work it out.
Yeah.
And then I had a case where we had 4 kids on one side and 1 kid that they on the other side of the fence. And the 4 thought that the one was manipulating and controlling mom. And we ended up appointing 2 co-guardians of the 4 so they could work together. Well, we had some pretty high drama right before mom died, and one of the 4, which happened to be one of the co-trustees, flipped camps.
Oh.
And so after mom died, we now have 3 with one of the co-trustees, and they have 2 with one of the co-trustees. And so now you got a co-trustee in each camp. And in this case, there was a lot of knickknacks. And the goal was to sell the knickknacks at highest priced value through the course of many years. 3 years, I think we had said 3 years.
Yeah.
And they just could not agree on anything. And I had done the trust, and so I said, look, I can help you if you guys will mediate. If you guys come to a point where you can't reach agreement, I can't represent 2 different sides, and I can't represent one side. And they couldn't reach agreement, so they both hired attorneys. They both fought in court as to who should have priority and who should be dismissed. And eventually the court just said, enough, we're going to appoint a commercial trustee. And ironically, it was actually Tim that was appointed when he was with the bank.
Gotcha.
At that. and he came in, and as a neutral third party, they held a sale, sold it at the highest value within a very short time frame, because that's what the court had ordered, because the family wasn't able to get along, and distributed the asset. So after that case, it just made me think, there are situations where families they have difficulties getting along, or they don't have anyone else. And a commercial trustee in those situations is very highly beneficial to keep that family conflict down.
So that also leads to a question about co-trustees, where my opinion's always been, please don't have a co-trustee. Just have someone that takes the weight of it and makes decisions and moves forward that you can trust. But what's your thought on co-trustees?
Yeah, the longer I've been in practice, the more I lean to where you've just stated, where if they're going to do co-trustees, I really make sure that do they get along, and what's the reason for it.
Yeah.
I've had situations where you have a local child but doesn't have much experience, and you have maybe a child that's in a different state that could handle it a little bit better. And the reality is they will both be calling banks. They'll both be doing different things. And so if they're both going to actually be taking action on the trust and gathering the assets, paying creditors, then I've been okay, as long as both of them are actually going to be taking action and they both will get along. But you're right. You've got to be careful.
Yeah.
With it. It is easier to name one and then have them talk to everyone, make sure everyone's in agreement, and then they can just move forward.
Yeah.
With it.
So have you found, other than Bank of Commerce that's here that's doing some of the institutional trustee pieces, what other solutions are out there that are institutional options when it comes to people locally that for trustees that aren't family?
Yeah, so I know U.S. Bank.
Are they still doing it though? I know there was a trust department, but with them selling out and
when they sold out, there was another trust department. To be honest, I can't remember the exact name. Okay. But I know that Doug Benson.
Yeah, he's a good friend of my neighbor. Yeah.
So I don't know the names. Tim knows all the names.
Yeah, it's all good.
But when that happened, I know that there is another trust department. As far as, I know there are other banks with trust departments.
I think, and I can't remember his name was, but there was a state attorney, quite prevalent state attorney in town that passed away a few years back. He took care of like the big players in the area. But Eskelsen, yeah. But he, Scott was his partner.
Scott Eskelsen and Martin.
Martin.
Yes.
When Martin passed away.
Correct.
I think he was the trustee of some of the trusts that were created under him. So, and I could be wrong about that, but I guess the question I have is, what prevents an attorney from acting as trustee on a trust?
So an attorney can, and actually
I can't. Financial advisors can't. But I've always wondered where you have an estate attorney who really has drafted those documents, understands the wishes of the family, has been integral in all of this stuff, has the ability to potentially be a trustee to help with that liquidation or whatever. Why more of them don't head down that path?
Yeah, I think for me, as a solo practitioner, until more recently, where we've now, we're up to 9 or 10, and not all of them are full time. It's a lot of them part time. Up until then, I really wasn't set up to do that. I set up to do the estate plan to get that in order, but just didn't have wasn't set up.
Yeah.
Skill set to do that.
Yeah.
With Tim being there, and with him having that experience and done so, having done that, there was a client that didn't have anyone and has a ton of stuff, and she doesn't have any children, and she's married, and he has children, but she's very, very particular about how she wants things to be handled. Mm-hmm. And so we've agreed to act as the trustee in that situation. And to move forward and make sure that her wishes are carried out. And so from our office, we're looking at it more now that we have someone that has experience, number one, doing it, and can move that
Yeah.
move that forward. I'll be honest with you. The other reason is because until we had that, it was cheaper to go with a commercial bank than it was to come with an attorney. Because at the bank, you're paying, 100, 150 an hour for them, and attorney, if we were paying 300 an hour, or the individual you mentioned, I think is a little bit more
Yeah.
than that. And so a lot of times it just came down to cost too, that they wanted someone that could do it at the best rate.
Yeah.
And as an attorney,
It was harder.
it was harder to do
Yeah.
that. So I think that might be another reason
Gotcha.
you don't see it as often.
Do you do much with probate?
Absolutely.
Okay. So I have some questions on probate. So
Yes.
I think first, one of the big misconceptions people have is that probate is a bad thing, and you want to avoid it at all costs. And I had clients in California where that absolutely was true. Like the average, I believe, probate solution in California was 3 years, like to resolve probate. And so having a trust in California was absolutely necessary for everybody and everything.
And the attorney gets a percentage of your estate by statute.
Yeah.
Too.
Yeah.
In California.
Yeah, so it's terrible. But in Idaho, probate's not really quite a big deal. I mean, I've heard of getting an emergency, the order of granting the letters of administration within a few days to really kind of a week on average or so. So it's not really a long consuming process to get the authority to move forward. And a lot of probates are able to be closed within 3 months if there's not lingering property issues that are out there. So probate in Idaho is really not quite a big deal, not necessarily something to be scared of, but what do you see as some of the problems that people get into when they either don't file probate correctly or just ignore it, or maybe it's even that you have a spouse that passed away and you don't do the simple things to just move property at that point that don't cost a whole lot of money to clean up. Like, what do you see within the probate process as being issues?
Yeah, so with probate, you're correct that probate's not a big, complicated process. It can be quite simple to get someone appointed. I would say my experience has been, if you're in eastern Idaho, it's still a pretty straightforward process. I filed, because everything's online.
Yeah.
Now I filed in different counties, and some of them are a little more difficult to get appointed and move forward. And so and also if you can't find the will, that creates a little bit of an issue, because then, or we're probating a copy of the will, then some courts require us to go through the formal court process, which is what it is by statute requires. And so then you have to have hearings. And the other thing with probate too is you've got to notify all potential heirs. So let's say you have a second marriage and you're giving everything to one spouse, and maybe you don't, and in certain situations you're not giving some to other children. If you have a trust, then you just administer that trust and you don't have to notify everyone. Whereas in a probate, you're having to give notice to the surviving spouse, but also the children of the deceased individual. And sometimes you don't know where they're at, you can't locate them. And so there's always this kind of lingering, have I really resolved this state, because you don't know where they are.
Yeah.
But with probate, essentially you're just submitting a petition to the court and getting appointed as the personal representative, and then gathering those assets together and paying creditors. If you have unknown creditors, then we publish notice in the newspaper, and they have 4 months to come forward and say, hey, we have a claim against this estate. And if they don't come forward in that 4 months, then they're cut off.
So, and there's an exclusion, $100,000 exclusion in Idaho. So if you don't own any real property, you can use that exclusion to not have to file the formal probate process. But
correct.
So one, can people handle that without using an attorney? And two, like, do people skip the process of notifying creditors? And if they do, what kind of problems can that resurface? And I think all you have to do is publish in the papers, like you said, right? Like 4 months. I don't know if you have to send letters to the major credit institutions and then publish, but what happens if people skip some steps in their probate?
Yeah. So with regards to the answering the question on the small estate affidavit, so if you have under $100,000 in your estate, then you can use what we call a small estate affidavit. And I always tell clients, go to the institution. If you go to a bank and there's no beneficiaries listed and it's under 100,000, then they're typically going to have a form that you can fill out and just use their form. There is a bank in town that their policy is that if it's over 25,000, then they won't do a small estate affidavit, even if it's under 100. I've got clients call me and we end up having to do the probate process to do that.
Yeah.
And so, but if the institution doesn't have it, then we can always do that small estate affidavit to be able to transfer that property for them. And the same with vehicles. If there's a vehicle that isn't in your trust, or if that's the only thing you have, then you can just do a small estate affidavit with the DMV and go forward with that. And then your second question, you're gonna have to remind me. Sorry.
It was really notifying creditors.
The notifying creditors.
Yeah.
Right. So after a person dies, then they need the personal representative or trustee is going to have to pay known creditors. So any known creditors, they have to be diligent to go find them and get them paid. Publishing in the newspaper is only if there's unknown creditors, people that you don't know where they're at. That's when you need to publish in the newspaper. In order to publish, you need to file the probate. So it's not, your obituary does not provide notice, and just giving a regular, you have to file probate with the court, get a case number, and then there's a specific form that we file with the court. And in Idaho, there's not pro se or do-it-yourself probate forms online. So I've had some clients tell me, well, I can just notify the newspaper and we'll just publish this. And I said, well, that's fine, but do you have the right form? Have you filed probate?
Yeah.
Do you have the case number and all of that? And so once you walk them through that, the reality is that unless they've been a personal representative and have sample forms that they can go off of, usually they recognize, hey, I need to hire an attorney to get that done. And
Gotcha.
And
so to add to that, when you have an older couple and one of them passes away, and you have titling on cars or the real estate itself, do you recommend at that point that they file with the the quick process to kind of change those names at that point? Because I've often run into people where they've just not done that until both spouses passed away, and then you're trying to find two different death certificates from people in different years.
to be honest with you, a lot of times they don't contact me.
Yeah.
When the first spouse dies, a lot of times I don't get contacted. If I do get contacted, usually it's them trying to do their estate plan, and then they're wanting to get things into a trust to avoid probate.
Yeah.
And if it's been within 3 years of the first spouse dying, then we have to probate. We have to go ahead and file for probate so they have authority to transfer it into the trust. If it's beyond 3 years, except in Jefferson County, so Jefferson County says it doesn't matter whether you've been dead 1 year or 10 years, you always have to probate.
Okay.
But in every county that I've dealt with besides Jefferson County, if you're beyond 3 years, then you can do what we call an affidavit of surviving spouse, attach the death certificate, and then it can take off the first spouse name off the deed.
Do you have a preference for doing it early or waiting in most places, except if you lived in Jefferson County?
Yeah. So for me, it's really the intent of what is the surviving spouse going to do.
Yeah.
If the surviving spouse, the surviving spouse is going to stay living in the home, isn't going to move, just live there, then a lot of times I'll see them not go through that expense to do a probate. And if they're not wanting to put it into a trust to avoid probate for their kids, then a lot of times I'll see people not really do anything when the first spouse dies, and then just handle it when the second one dies.
Yeah.
If they've had it in a trust, it doesn't matter.
Right.
If they've moved it into a trust, then the surviving trustee can sell that property, whether it's 1 year or 10 years. And so it just removes that issue. So a lot of times the discussion, when I have a couple come into me to figure out whether they're going to do a will or trust, I'll say, well, the will is going to cost you, it's cheaper than a trust, but the reality is if you own any real estate, you're going to have to go through probate anyways. And you might have to go through probate after the first one dies if you're wanting to move within that 3-year mark, and presuming you live outside of Jefferson County.
Yeah.
Or you can pay, you might have to probate after the first one to die, and then you will have to probate when the second one dies. Or you can pay a little bit more money for a trust and just get that property into the trust now, and then you don't have to worry about probate when the first one dies or when the second one dies, as long as you've been proactive to put the property and accounts into the trust.
If you funded it, you actually went through the process and moved the assets into it, got them retitled.
Correct.
Yeah.
And so cost-wise, a will is cheaper, but in the long run, you've got to think, I got to pay for the will, potentially 1 probate, and potentially 2 probates, depending on.
So will's $1,500 or so, somewhere around there. But probate, I think, somewhere $2,000 to $2,500 to go through probate.
Yes, so we charge $1,600.
$1,600?
$1,600 to get the person representative appointed.
Okay.
If you need to publish in the newspaper, it's another $600 is what we charge.
Yeah, so you're over $2,000 at that point.
Yep. And then if you're needing to file inventories and get settlement agreements between people that are disputing, I've had that run from $2,000 to $10,000.
Yeah.
Plus, just depending on how big of a dispute.
And you might have to do that twice.
Side.
Some of that twice. So, yeah, interesting. So, but that does open up another question. So, in the financial advising world, I mean, we're meeting with clients often, all the time, going through, making sure everything's buttoned up. They're having the spending they need, any goals changing, any life events changing, changes in all kinds of situations. But, without major life events with a spouse passing away or something else or a child passing away, I guess I haven't been as active in forwarding without those big life events back to the estate planning attorney whose original documents they came from. But so the question I would propose to you is, how often should people be in contact after their documents are created? Is it just those big life events, or how do you feel like people should stay in touch with the estate planning attorney that's helped them create a plan for all of their assets and how that flows?
Yeah, definitely, like you say, when there's big life events, or if they're wanting to change who their beneficiaries are or change how their distributions are going to be, then definitely having contact. The other time is as people age, then that line between when they're competent and incompetent kind of gets a little bit blurry. And so if you have an individual that they know that they're moving into that age of dementia, then having more contact with the attorney is good. I know I've dealt with one situation where an individual had me do their trust, and I'd met with him 3 or 4 times over the course of 3 or 4 years to make different little amendments. He wasn't married and didn't have any children. And one day I got a call and he says, I need to come make another change. I says, well, great, come on in. Well, his nephew brought him in, and his nephew was a Christian minister, and the nephew said, my uncle wants to change his estate plan to give it to me. I said, well, let me meet with your uncle here. And so we went into the room, and the uncle told me, I want to give everything to him because I want this to be used to benefit the world, and my nephew will do that. And because I had been meeting with him on a consistent basis, I knew that he was in decline. And I had had contact with the niece who was the successor trustee that lived out of state, Missouri or Illinois somewhere.
Yeah.
And she had actually got wind that nephew was going to show up and had alerted me to that fact. And she had told me that she was coming into town. And so when I met with the uncle, even though that's what he wanted me to do, I stalled. And I said, well, it'll take me about 2 weeks. And so he's like, well, can't you get it done now? And I said, no, it's just going to take, with my current load, that's where I'm at.
Yeah.
And we went and told the nephew, and he was upset with us. And sure enough, that was a Tuesday. Thursday, he disappears. Friday, the niece comes into town, and and we never made the change. He passed away within a couple months. I got a call from an attorney saying, hey, this should have been changed, and why wasn't it changed? And I told him, look, this is the facts, and I'm happy to be called as a witness.
Yeah.
This is what happened, and I never heard from the attorney again. So if you're getting into that stage where there's dementia, and I guess I'll share one other little quick story is
these are
right
great.
now I'm dealing with a situation with a guy who's got dementia and has put his daughters in charge, and there's some other family members that aren't in agreement with what the daughters are doing, and the daughters put him in Morningstar, and he doesn't want to be there.
Yeah.
And fought to not go there. But the reality is that his care necessitated that, and so that's what's needed to happen. But now the family's at a fight between what he wants, and some family is sided with him and isn't supporting the agents that he picked while he was well. And so this is a situation where, if having constant contact with the attorney as he moves into that more dementia, to really know what he wants and to help him stay clear on what he wants, even when the person he's chosen to help him is doing what's best for him, but he doesn't feel like it is.
Yeah.
And it exacerbates because of the dementia.
That
And
story
so-
helps a lot, I think, too, for me, because we deal with that all the time. And, people that are getting older and you start worrying about where the distributions are going, and if there are requests that are coming that are just strange.
Yep. Vehicles start to disappear.
Strange
people.
things, and,
Yep.
and then the fraud that is out there. I mean, my own mother twice was taking advantage of Facebook fraud, and and got those things fixed up. But I've had many clients that we've caught or stopped fraud from happening, and when they get older and they're easy to manipulate. Unfortunately. And so having, I always try to have a trusted contact that we can call, whether it's a daughter or somebody, a non-spousal trusted contact, I think is important as well. So that we can go to talk to. But as you're talking about the estate planning and talking to the attorney, I think I could do a better job of making sure that these conversations are routed back through the estate planning attorney, where those documents were created and rest and pulling that in.
Yeah, and as you see that they're moving towards that dementia, to make sure that they're having contact with the attorney.
Yeah.
Because what ends up happening in this other case I just mentioned, where the family's disputing what needs, is that we tried to use just the powers of attorney that were in place when he was well. But other families have got him to sign other powers of attorney.
Yeah.
And so now there's a conflict of who has authority to help him. And so then what ends up happening is we end up filing a guardianship to just try and put a pause to everything. And I just feel like it could have been avoided if there had been a lot more open communication amongst the family and just all working together.
Yeah.
And once again, the estate planning attorney, if he's had that contact, can work with the financial planner, can work with the medical doctor to really say, okay, what did he want?
Yeah.
And who did he want to have help him?
Yeah.
And let's all rally around that. Decisions he made when he was well, rather than fight. And when they're not well.
Yeah, and it gives one more person to be a part of the witness if needed, to say, these were the wishes when they were healthy and well, and then when they weren't anymore, things changed dramatically. And what do you hold as the primary documentation? Is it the stuff when he was healthy, or the stuff that happened after he was in decline? Right. And what were the wishes? And so hopefully, everybody's doing a good job, where the estate planning attorney is having all those conversations and documenting it, but the financial advisor on the other side is also documenting all of those conversations and those needs, and informing people and their trusted contacts, and that we all can work together to make sure that the wishes of this person are fulfilled at the end the way that they really wanted them to be. So I think that's really super important.
And that brings up a question I have, is how often do you have contact with those support people and the successor, just other people? How often do you have contact with them?
Honestly, because they're getting paychecks every month. like there is a lot of communication between clients and their financial advisor. And as they get older, when we're having conversations with a trusted contact, I mean, it can be monthly, if not a little more than that you're saying, because every single time that because I mean, I don't want to say we're the gatekeeper to their money, but we kind of are, because if I got a $3,000 or $4,000 or $5,000 distribution happening every 5th of the month, and all of a sudden I get a call and says, "Hey, I need $15,000 to go here." Well, that's not normal. So can you explain what's going on? Are you buying a car? Are you doing something? So some of those explanations of what they're doing, especially if you've noticed that they're starting to be in decline. Great. I got that noted down. Let me follow back up with you, and then you give their daughter or whoever is their trusted contact a call, and sometimes it's a friend, and say, "Hey, I got this request. It's a little out of the ordinary. Not sure, if you've heard anything. Well, let me call mom. Let me call dad. Let me just check." And so that's how that happens. So usually anything that's out of the ordinary, we get increases. I need to go from 5 to 7, or I need lump sums to go somewhere. All those things can be easily caught. I had a peer in Provo who, I don't know if you've heard anything about the gold FBI scam that's going on with people, or that their FBI calls and they need you to go buy gold, and then there's going to be someone that comes to your door to get this parcel of physical gold that you've bought, and it's a whole scam. And there was people that were not even in real mental decline, but they were just gullible in their older age, right? That got taken advantage of, and they tried and tried and tried to find out what this is an abnormal request to have this much money go out, and so the first chunk went out, and then they got a second larger chunk request, and you're like, there's something really off about this. And so we do have the ability to put some pauses on some of stuff like that and try to dig into it. And in most cases, we find out that there is some type of fraud and are able to stop it. It might not have stopped everything because people lie to you. But I mean, lots and lots of times we were able to kind of filter that and stop fraud from happening, which is good.
And I haven't heard of that one, but it sounds very familiar to. I've dealt with several situations. They make contact with someone and they'll say, "Well, sell your home, send me the money, I'll buy us a new home, and then I'll use part of that money to fly, pick you up, we'll get married, and we'll go to our new home."
Oh my gosh.
And finally we were able to figure out what was going on, and we had to file an emergency guardianship in that case, conservatorship over the money, and be able to get control of that and talk with the realtor and be able to put a stop to that sale, because she'd already drained other accounts. I've seen people drain their retirement accounts to these frauds. Yep. And it's just sad when people are taken advantage of like that.
It is absolutely terrible. It's one of the worst things ever. I had a client who wouldn't tell us what was going on. And he didn't have a lot of money. And you have someone that loses what little they have. I mean, there's no recovery for it. But again, Facebook fraud. I mean, that's where most of what I hear come through is some type of social media where they were in contact for somebody. And you should never send money to anybody that you haven't met in person. And even then question it, right? But moving on from that, estate planning documents are very specific. Here's the beneficiary, here's your personal representative, here's the assets are going to be titled, here's how they're going to go. But how do you suggest passing on values, stories, and potentially just instructions that might not be written inside of the documents themselves?
Yeah, have family reunions.
Family reunions, that solves it.
I don't know if it solves it or not. I had a client call me one day, and we did their estate plan, and he says, now this is going to guarantee that there isn't going to be any fighting or contention because I've laid out my wishes.
Yeah.
And I said, well, I wouldn't go that far. This will help. You've done a good thing to make sure it's clear who your agent is and how you want things to be distributed. But the real way to make sure that there's not going to be a dispute when you die is you make sure you have a relationship with each one of your children, with your grandchildren. And if that means spending some of this money to have a family reunion and you all get together, then that's great. Last week, my wife is the third of 13 kids, and we've got 80 some odd.
Your wife's mom had 13 kids?
She did.
You have 9?
We have 10.
You have 10?
Yeah, 5 girls and
families.
5 boys.
Big families. Yeah, man.
And I'm the second of 9.
Wow.
And so, we've got 60 some odd cousins on the Harrison side and 80 plus cousins on my wife's side. And,
wow.
And her parents are both passed. They both passed at 66 and 70.
Not old.
No, they were not.
Wow.
And so every year we get together with them, and this last week we had we rented out it was actually a Christian retreat place that has a big lodge and lots of little cabins, so it fits our family good. And we just go there and build relationships with each other, and it's good. Our family, they get along. We enjoy spending time with each other, and I think in my mind, that's the best way to make sure that you don't have conflict, is by maintaining those relationships and building those bridges now.
Yeah.
So that's what will last. You have that culture of a loving, happy family. And when there's been difficulties in the past, it's been neat to see people try and work through that, and just be able to, as they have to address who gets what and where things go. I have one client that's been able to make amends with his kids because there wasn't anyone else to leave stuff to, and he really wanted to leave it to them, and so he's been proactive in trying to rebuild that relationship. And I'm not going to say it. Every relationship and every family relationship is going to be mended or whatever, but it's been neat to see that some of that healing.
That is awesome.
Happen.
Yeah. So on my side, heirlooms especially, I think are something I talk to people about all the time, where it might not be something that's listed specifically in a document somewhere, but whether it's my dad has an old 30-06 that that's what I learned how to shoot with. It'd be nice to have that Springfield 30-06. I don't shoot a 30-06 anymore, but that's a pretty neat heirloom. He also he was in Vietnam, and so his bronze and silver stars and his old blouse that he has would be fun to create a shadow box and put some of his war medals in there and maybe some pictures from him and just create some things around those. So those things I think would be nice for people to jot down. I had a client who's like, well, it's silly, but there's just one thing I want from my parents' house. I'm like, what is it? He's like, it's this flowery bowl that we put mashed potatoes in on Sundays when we have our family dinner. He says, I don't even know, it's probably a $10 bowl from Walmart, but because that's where the mashed potatoes go every Sunday, that would be the thing that I would want to have to remember my parents by, this stupid flowery bowl that the mashed potatoes went in. So I encourage people to have conversations with their kids about heirlooms and things that might be important. It might be an Afghan that grandma sewed, or a watch, or the wedding ring or something. But if they have some conversations around what might be heirlooms, what might the kids think are things that they want to remember them by, I think is important conversations to have as well. So
and leaving stories about your family too.
Yeah.
Keeping stories. I know my mom's always been really good about that, is talking to us about her parents and her grandparents, and I have an uncle that's did a 1-page document on all of our ancestors, and so just leaving stories for your posterity, I think it's a good thing.
Yeah, that is awesome. Well, I think I've taken enough of your time out of your busy day and your schedule this week, and I hope this was fun for you.
Absolutely.
This has been really fun for me. I've really enjoyed having you here. I'd love to have more of these conversations with people, and I think they're valuable for others. So I appreciate you spending some time with me today.
No, I appreciate you. Come over. I believe in collaboration.
Yeah.
I believe that as we really work together as professionals, I don't have all the answers. You don't have all the answers.
Yeah.
The doctor doesn't have all the answers. But I believe it's as we all come together and we collaborate and work together, that we can do what's best for our individuals and clients.
Yeah, absolutely. Thank you. So.